Greetings and welcome to the Quarles Brady webinar presenting the case with the jury in mind. This is our first program in the Litigation Leaders Webinar Series. My name is Ed Salanga and I'm the National Practice Group Chair of the firm's Litigation and Dispute Resolution Practice Group. I'm pleased to introduce Mark Kircher, a partner in the Product Liability Practice Group. Mark is trial counsel of choice for major manufacturers of motorcycles, construction, and agricultural equipment and consumer products. He has tried over 60 civil trials to verdict in 24 states and acts as national counsel with respect to pattern litigation, where his skills as a trial lawyer enhance the value of Q&B's representation. Mark and I are very pleased to be with you here today. We have a few housekeeping items to go over before Mark begins his presentation. First, you may access a copy of today's presentation and other forms and materials in the handouts panel of the webinar dashboard. Second, we have muted all phone lines for those dialing in and for participants listening to audio via computer, so you will not be able to speak. We are in listen-only mode. Third, we would like you to be aware that this presentation is being recorded, and an electronic survey will be emailed to you after the program. Finally, if you have a question during the presentation, please type your question in the Q&A box located in the upper right-hand corner of the webinar dashboard and submit. The conference host will make sure the speakers receive the message. Every effort will be made to answer questions in the final minutes of our time together today. Mark, take it away.
Thank you, Ed, and greetings to everyone that's participating in the webinar. As Ed mentioned, I'm in the Products Liability Group at Quarles Brady, and so my comments today are based, generally speaking, as a defendant in a products liability case, which will involve complex engineering issues and plaintiffs who present very sympathetically due to grievous personal injuries or having been killed as a result of an accident. So, first point or basic principle I'd like to mention is that a successful trial informs and persuades. Obviously, the jurors are strangers to the story that gives rise to the case, and it's incumbent on both sides to educate them. But if you simply educate and don't persuade, you're unlikely to get the result that you'd like. And so to be persuasive, there are a number of observations I'd make. First, you should structure the order of your evidence to correspond to your theory of the case so that the jury not only learns the facts, but learns them in an order that portrays them in the best light for your client and its position. I would also suggest that if anybody thinks it's all right for a defendant to wait until the plaintiffs have rested to start making its case, they are incorrect. They have waited far too long. You begin telling your story, even though it's not technically the way it's supposed to work, in voir dire and obviously in your opening statement. But as a defendant, you should tell your story during plaintiff's case in chief as much as you can, using cross-examination of plaintiff's witnesses as an opportunity to essentially argue to the jury, with the plaintiff's expert or other witness simply acknowledging the correctness of your assertions. For example, if you know that your defense in a case is going to be that the operator of the, say, motorcycle committed an error, you can have plaintiff's experts acknowledge on cross-examination the studies that suggest most motorcycle accidents are due to operator error. That way, when your experts express that opinion, they'll be seen as confirming something that you made the plaintiff's expert admit. So I think you begin telling your story the first moment you can, which is in jury selection, and continue doing it throughout your opponent's case and then during your case in chief. The next point I'd like to make is that you really need to stay out of your own way. Trial lawyer's relationship with the jury should, in my view, be entirely confined to the context of the trial that you are, or the case that you are trying. I have seen other attorneys during the course of jury selection or argument or even witness examinations comment about other cases they've been in, other juries they've picked, other experiences they've had that, to my mind, add nothing to their presentation, because those are subjects about which the jury is never going to learn more. And it really deflects the jury's attention from the message to the messenger. So as the messenger, I would suggest that you stay out of your own way and keep the focus on the message and not on you. Next, there are always challenges in any case. Some of them may be factual inconsistencies, some of them may be emotional challenges. They have to be anticipated. Generally, they're pretty obvious, but they have to also be addressed proactively, head on. For example, if you have a case where the plaintiff has been rendered paralyzed and they're in a wheelchair in front of the jury, it's my practice in cases of that type to ask the jury to focus on the plaintiff, to acknowledge their situation and their plight, and then understand that despite all of that, we are going to be asking for an outcome which would seek to have that person not recover damages, at least from our client. You need to have that as a concept early on because it will be the 600-pound gorilla in the room if you don't. Next point would be that credibility is a sort of a limited asset. Everybody starts with the presumption of credibility and honesty, and there's about an unknown quantity of patience and indulgence that the court and the jury will afford you. And so not knowing how much you have, it needs to be treated very carefully. With respect to the court, I am very judicious in pretrial motion practice. I tend to avoid discovery motions if possible, only because you see in the eyes of the court the same visage that you see on the face of parents separating fighting siblings, especially young antagonistic ones. No one likes to do that, and judges really don't like to have to skip between warring factions on discovery issues. If you wear out the path to the courthouse before trial starts, I think you're less likely to get indulgences during trial. With respect to the jury, most of our trials are out of state. And so we're in a strange town, and so I always advise my team that from the time we step off the plane, we are on stage. And so you have to be on your best behavior, not just in the courtroom, but at the hotel, entering the courthouse, pretty much anywhere you are, because you never know when you might encounter people that turn out to be jurors or court staff or otherwise. If you happen to be seen by the judge jaywalking to the courthouse, that might not put you in the best possible light. I know a man who tries cases around the country like I do. He was seen to be waiting at the crosswalk in the rain to cross with the light, and the judge recognized him and said, "I saw you waiting to cross with the light." Little things like that can have an outsized influence. Talk a little bit about voir dire. Voir dire is the only chance as a lawyer that you get to talk with and not at the veneer. And so if you can, I would recommend taking the opportunity to have a bit of conversation with every prospective juror. In some jurisdictions where you have to question an entire courtroom, 50 or 60 people, that isn't practical. But in many jurisdictions where you're only examining 6 or 12 at a time, you can, and I would always take the opportunity to do that, because a rapport, this is the only time you can actually get rapport with a juror where they can speak back to you and acknowledge the message you're trying to send verbally. Remember that jurors are not volunteers. These are folks that were summoned there against their will, likely, and taking them out of their daily lives. For that reason, I would caution everyone to beware of the willing juror. I always ask in voir dire near the end if anybody wants to be on the jury. And if they do, I'm very, very cautious about keeping them on the jury, because that, to me, suggests that they have an agenda that they want to deliver through participation on the jury, and I would prefer that nobody have an agenda coming into the beginning of a case. I think it's important to acknowledge the conditions of jury service for a couple of reasons. And by the conditions, I mean, picture this. You're picked to sit on a jury. You have to show up, meet a bunch of other strangers, and sit in a room until someone opens the door and marches you into the courtroom, where they sit you in a box, and you can't get up and leave until the court says you can. In the meantime, you have to listen to lawyers, and then witnesses, but mostly lawyers. So I think it's important to acknowledge that, and perhaps make the task a bit more palatable for the jurors by suggesting, look at the reality of the situation. You sit in a special place. We rise when you come and go. The job you do is as important as the judge judging the law. You judge the facts. And by doing that, you can get them to treat their work with a bit more reverence, shall we say. And it also allows you to be a little self-deprecating. I think it's important for trial lawyers to be self-deprecating. Many that I run into are anything but if you can suggest that we recognize you have to sit and listen to lawyers all the time, a fate worse than death, or prove an unusual punishment, almost always gets a chuckle or a smile, and it humanizes you with them. I think you should forecast where deliberations are going to be difficult. But in this regard, I generally forecast that the difficulty in deliberation will not be because the evidence favoring one side or the other will be closely divided. I generally take the position position that it's not, but rather than it will be, in my cases, the sympathy factor that the jurors will have a hard time disregarding, even though they are uniformly told they cannot base their decision on sympathy or passion or prejudice. Getting them to consider sympathy, acknowledge its role, and then that it can have no role is important up front. I think you must then be very explicit about what you're going to ask the jury to do. You have to set the expectation. I'll use my example of a case involving a paralyzed plaintiff. I have to ask the jurors whether they can look at that person and yet fairly consider the evidence and perhaps reach an outcome that doesn't favor them. Because you have to tell them exactly what you're going to ask them to do at the end of the trial, and that is to secure their conditional commitment to your desired outcome. And I'll do this personally with each member of the panel, assuming you're questioning 6 or 12. For example, Mr. Plaintiff is paralyzed, and he's obviously suffered a great loss. But if the evidence would support it, would you be at all hesitant to return a verdict in favor of my client, by which Mr. Plaintiff receives nothing from my client? $0, no damages. Make it explicit so they know that's what you're going to ask for, and get them to acknowledge, if they will, that they could reach that result if the evidence supported it. If they won't, that's a good juror to probably strike, or at least try and get stricken for cause. But if you secure their conditional commitment to the desired outcome, you inoculate them to the sympathy issue, and you get them thinking that a defense verdict is a possible outcome in the case. They have to have in mind from the beginning that the outcome you want is one of the possible outcomes they could reach. And finally, assuming that you're prepared to deliver your evidence in a precise way, I would ask the jury, because of the importance of their task, and make reference again to the ceremonial pomp and circumstance of being a juror, that they demand precision from both sides. It essentially is a challenge to your opponent, and if you know that your opponent's case has some either logical or evidentiary issues or challenges, this is a way to have the jury looking with a critical eye at the presentation that your opponent makes. Now, I'd like to make a few observations about opening statement. With the advent of social media, people's attention span is incredibly short, only a matter of seconds. And so when it's my turn to give an opening statement, I will secure the attention of the jury through the may it please the court routine, where you ask, may it please the court, counsel, Mr. or Mrs. Plaintiff, and ladies and gentlemen of the jury. At that instant, you have their attention. In the next 20 seconds, you articulate a concise theme, a declarative sentence without commas. We're here because X. Your theory of the case, your theory of defense. The jury has to hear that immediately and remember it, and they should associate everything they hear from your side of the room, your table, with that theme of the case. It has to be very clear and declarative so they know what your position is from the get-go. Then I like to narrow the matters that are in dispute. For example, almost universally, in the cases I try, we acknowledge that damages have been suffered, but we dispute who's responsible for them. As such, we don't generally put on any evidence that relates to the damages case. Rather, I will suggest to the jury that while they have been impaneled because there are issues upon which the plaintiff and the defendant cannot agree, there are many things that are not in dispute and which they don't have to deliberate about or concern themselves with. For example, it's undisputed that the plaintiff is a good person, that they've suffered a serious injury, that the circumstances of their life have changed, that if the outcome could have been changed by going back in time, everybody would do that. It makes essentially the strength of your opponent's case hopefully seem like a secondary consideration in the eyes of the jury, so they focus more on what you're interested in, which in our case is generally the liability question and not the damages question. You should explain why your side of the argument will win because the relevant evidence supports it, and then you should forecast the request for the verdict you're going to make at the close of the case. In other words, I will tell the jury that at the end of the case, I'll ask you to return a verdict in favor of my client, because that's what the evidence will support, and because of what the evidence will show, a verdict in my client's favor will be the fair thing to do and the right thing to do. If perhaps not the easy thing to do, given the fact that the plaintiff has sustained injuries. I adopted that from a trial lawyer that I saw use it in 1987. I do that in every case, and it seems to work pretty well. It's a nice way to package the issue. Now, I want to talk briefly about witness examinations, direct and cross, and it is not my purpose to get into the subject of how to do a good direct or a good cross, because that could be the subject for an entire webinar in and of itself. But because the jurors are strangers to the case, doing direct examination, you must provide context for what you're having your witnesses talk about with introductory phrases so the jury understands what they're going to hear and why they're going to hear it. Good witnesses, experts in particular, who have done this before, will know to look at the questioner when they're on direct exam and then turn to the jury and answer to them. But many fact witnesses or inexperienced experts don't get that all the time. And so if you're allowed to do it and you're in that situation, I will position myself at the far end of the jury box where the witness can't help but look at me and the jury at the same time, so that the communication on direct is the witness to the jury. I think it's important to demonstrate efficiency and progress with your examination outline. I have been told by a number of jurors over the years that they really appreciate seeing that I'm making progress because I have a habit of checking off topics and turning pages as I go along. It diffuses what I call the church sermon issue, where you're at a service and the officiant is giving a sermon and you have no idea how close they are to being done. Well, if the jury can see you checking things off and moving from top to bottom and from page to page, they know you're making progress, and I think it alleviates a bit of tension or concern. Practically, it's smart to prearrange admissibility of exhibits so that you don't have to argue about that during an exam, and have your trial assistant, who will be running your technology, present them when you need them because they have a copy of your exam outline as well. If you can all avoid giving testimony through playing depositions, video depositions, do it. Video depositions are human ambient. They knock the jury out in no time. Think about a good popular TV show. There's maybe 24 minutes of content in a half-hour show, and that's meant to be entertaining. Depositions aren't entertaining, and I've seen any number of juries just rendered catatonic by watching hour after hour of video deposition. If you have the option, have it read in, because at least then there's someone alive in the witness box speaking to the jury, and try to do it in short increments if you can. With respect to visual evidence, I think if you can avoid presenting it on personal monitors, great. Many wired courtrooms now have in the jury box monitors for each juror, or that jurors are supposed to share. I really don't like those at all, because if the jurors are looking at little screens in front of them, they're not looking at me, and I can't direct their attention as I could if I had a large monitor that I was standing next to, that I could make reference to, sort of like Vanna White turning the letters, when Pat Sajak tells her to. You really want their attention on the exhibit and the lawyer at the same time. So if you can avoid personal monitors, do so. It's not always possible. Obviously, your visuals should be simple and uncluttered. And I'm going to show you an example of progressive callouts. It's just a brief example of the sort of trial technology that's available now to make a very professional and effective presentation. In terms of cross-examination, I was once told that you shouldn't kill the witness until the jury gives you permission to, and it's good advice. You may have an adverse expert or someone that you, at some point, will get fairly confrontational with or have some very good impeachment to exercise. But until the jury understands that there is tension between your position and the witness's position, and can begin to understand the line of criticism of the witness that you're pursuing, it would be a mistake to simply come out swinging, throwing haymakers from the get-go. The jury won't understand why you're doing it, and they might view you as being, rather rude while you do it. Obviously, as a cross-examiner, the discussion is between you and the witness, not between the witness and the jury. So you need to exercise polite control through your cadence, to asking proper questions that don't allow narrative responses. And it allows you, if the witness can only say yes in response to all of your questions, the opportunity to essentially make an argument to the jury by mouthing propositions to them that are central to your case, and having the witness agree that they are reasonable propositions they agree with, so on and so forth. If you can get a crisp tempo, but one that isn't too rapid, I call it welcoming, all the better, because the witness will get into a routine of responding in the affirmative, even to questions which, if they weren't in such a routine, they might not. Many depositions are taken on video, and many people have often been enamored of preparing impeachment by taking the answer that you know the witness is going to be forced to give and actually playing that question and answer to the jury. I've tried it several times over the years, and it never works as well as simply, in my view, giving the witness a transcript and then directing them to the page in line, asking them to follow along while I read the question and the answer, and then having them acknowledge they gave the testimony and that it was under oath and it was the truth when they gave it. So as interesting as it might seem to be able to impeach with video deposition testimony, in my view, it's simply too slow, and it takes away from the impact of the cross. Again, demonstrating efficiency and progress with your outline is always welcomed by the jury. Generally speaking, jurors will reward counsel that they perceive as treating their time as very precious, and they will penalize counsel who they perceive as wasting their time or not being efficient with it. Again, you should display your visuals centrally if you can, as opposed to on personal monitors. And now the next 3 slides are just examples of progressive call-outs where I would like the jury to pay attention to a particular passage from a police report. So you would start with the report, the page from it, and then pull out the portion of it that contains the information you want, and then highlight that information. And this can go on for as many steps as are required, but it's a nice way to orient the jury to what they're going to see, and then which part of it they should pay attention to, and what part or what information you want them to derive from it. With respect to exhibits and trial technology, obviously these days everything is almost always presented electronically as opposed to 30 by 40-inch foam core slides. So you have many, many more options for information you can present. Visually, you need to be discerning in how much you present to avoid overloading the jury. Always get admissibility and publication issues, in other words, your ability to show an exhibit to the jury, cleared in advance. And your presentation must be prompt and correct. When you call for the exhibit, the right exhibit has to show up on the screen. But of course, that never happens 100% of the time. Technical difficulties will arise, and when they do, it's very important to maintain composure with your team. I have seen opposing counsel have a problem with their technology, that exhibit isn't coming up, and I've had them not treat their assistant who's trying to operate the technology as politely as they might have. I believe that when technical difficulties arise, the jury has a window into your character. How do you treat staff and your assistants? If you're polite and patient, they'll appreciate it, because the jury is associating or identifying with the poor person trying to run the technology and not the lawyer. So it's important that you treat them well. In almost all of my cases, our technology people are superior to the other sides, and we're often asked to assist, or we offer assistance with getting an exhibit that the opponent wants to show up on the screen. I think it's important to accommodate requests for assistance like that, because you garner respect from the court and the jury. I always provide my outline, whether it be an argument outline or examination outline, to the assistant who is running the trial technology so they can follow along, and exhibits can appear on the screen when I get to that part of my outline without having to expressly ask for them. Obviously, rehearsing this is highly recommended to make sure that you get what you want when you want it. And again, progressive callouts and highlighting can illustrate the logic of the point you're trying to make. Now, a few things about closing argument. I will always lead with the theme of the case from the opening, where in the opening you will say the evidence will show, that's TEWS. Now in closing you say the evidence has shown. And I start with the proposition that I opened with. We're here because X. The evidence has shown all the things I told you it would show during opening. When appropriate, I would rhetorically criticize opposing counsel as opposed to the opposing party, because the lawyers are generally viewed as equals as opposed to a large company versus an individual. And by rhetorically criticize, ask questions like, well, why didn't attorney X provide this important evidence to his or her experts until the 11th hour, if at all, for example. In cases where your opponent gets to close first and then you close and then they get to give a rebuttal, I think it's important to point out to the jury that you'll soon be done talking. That generally elicits a bit of relief from them. But then to tell them you can't get up again. The other side's going to get up and say things that I'm going to really disagree with, probably strongly, but I'm not allowed to get up and respond. And it may occur to you that that's just obvious, but actually, I think it introduces a bit of tension into how the jury is listening to the other side's rebuttal. Because as they hear the other side's rebuttal, they may be thinking, well, what would the other lawyer be saying in response to this right now? And so it at least keeps your positions somewhere in the jurors' minds as they listen to the other side's rebuttal. The next one, this is the nuclear option. If you can, you might consider putting some questions on a screen or maybe on phone core for your opponent to answer. Why didn't the opponent's expert do X? Why didn't they tell their witnesses Y? Rhetorical questions that reinforce your criticisms of your opponent's case. It puts your opponent in an unenviable position of either getting up and ignoring the questions, turning off the screen, taking them down, which obviously tells the jury they don't have good answers, or they may take the bait and start answering your questions with the limited time they have left for rebuttal, which is also a good outcome. Finally, you repeat the ask from the opening and tell the jury why it should be granted. Because giving you the verdict you want will be the fair thing and the right thing to do, even though it might not be the easy thing to do. And in conclusion, trials are not nearly as interesting as they look on TV. Everybody should keep that in mind and therefore try to be concise and as interesting as you can be. I think in my experience over 34 years, juries want to get to the right answer. They want to do the right thing. They appreciate people who treat their time as very valuable by being efficient in thought and presentation. If you don't want to deal with bombshells, steal the thunder whenever you can. You tell the jury about the difficult issues in your case from opening statement and on through so that when they hear them, they're not surprised. Finally, I believe America is the only country that allows jury trials of right in civil cases. It's a luxury. I think we should all express appreciation for the process and our opportunities to participate in it. And with that, Ed?
Thank you, Mark. I don't see any questions, but if anyone has any questions, please type a quick note now. Otherwise, we both hope you enjoyed our first program in the Litigation Leaders Webinar Series. We hope you'll join us for our second program in this series. It's IP Litigation Advocacy, and that's going to be presented by our partner, Kristen Graham Noel, on April 25th. Thanks, everyone.